already in an accident or a lawsuit was filed against you, it is now too late to do anything, because whatever you do right now will be a fraudulent transfer. Well, what does it mean? Why is it a scary thing? Why is it a scary thing for our client to engage in a fraudulent transfer? Okay, some people think that the fraudulent transfer is the same as fraud. You now know that it's not. A fraudulent transfer is a term of art, refers to these types of transfers that we just discussed. It's nothing to do with fraud. So what is the scary thing about engaging in a fraudulent transfer? Is our client going to go to jail? Well, there's no debtor's prison in this country. Penalties? No penalties for a fraudulent transfer. Caning? I mean, what happens if there is a fraudulent transfer? There is really only one remedy. And this is true in any state of the Union. There is really only one remedy, and that is to recover the transferred asset. I transfer my home to my brother. The plaintiff proves that it was a fraudulent transfer. They basically get to go and take the house back from my brother. The real estate developer transfers his assets to an LLC. The plaintiff proves that that was a fraudulent transfer. The plaintiff gets to go and recover the assets from the LLC. They basically get to unwind the structures that we have set up. This brings us to the most important point of today's presentation, which is it ever too late to plan? Is it ever too late to do something? Let us say that our client is subject of a lawsuit. The lawsuit has already been filed. From an asset protection standpoint, there are two choices that he has at that time. Choice number one, do nothing. Simple to implement, inexpensive, but if the plaintiff gets a judgment against our client, what are the odds that the client will lose his assets if he has done nothing to protect them? Well, somewhere close to 100%. Option number two, do something. Do something to protect your assets. And if you do that, maybe, and only maybe, will the plaintiff challenge that as a fraudulent transfer. And if the plaintiff challenges it as a fraudulent transfer, maybe, and only maybe, will they be successful. And if they are successful, maybe and only maybe can they get to the asset that you transferred away. Because that's not always possible. So on the one hand, do nothing, 100% chance of losing your assets. On the other hand, do something, fairly good chance of keeping your assets. As I explained earlier, at a statistical level, a very good chance of keeping your assets. So what is the only downside of doing something to protect your assets? The worst that can happen, you wind up right back here as if you've done nothing, because the plaintiff can now reach the assets that you transferred. So what's the only downside of trying? The only downside of trying are the transaction costs. What are you going to pay your attorney? What are you going to pay your accountant to help you set up these structures? Okay? That is the only downside. Let me give you a very good illustration. This is a recent client case. I have a client who has a kid. The client is a doctor. The kid decides to become a real estate developer. Well, the kid has never done anything connected with real estate. He doesn't have any sort of a track record. So if he wants to become a real estate developer, how does he go to a bank and borrow money? Well, he can't, unless daddy, the doctor, guarantees that loan. So daddy goes with the son to the bank. Daddy signs a personal guarantee, $5 million personal guarantee. This, unfortunately for my client, took place about 3 years ago, right before the real estate market started going downhill. This is when his son decided to become a real estate developer. Well, as you can imagine, a year or so goes by, the project is upside down, and the son wants to walk away from the project. Well, if the son walks away to the project, what happens? Well, the bank is not going to call the son. They know he has no assets, nothing to pursue, but they know that daddy is a successful physician. Daddy has lots of assets. And he signed a $5 million guarantee. And daddy had sufficient assets to cover the $5 million guarantee. Most attorneys would tell that doctor, there's nothing you can do. You owe money to the bank, they're holding your guarantee, they will sue you, they will get a judgment, and no matter what you do today, they will get to your assets. So what happened in this case? He was being pursued by a very large bank. I'm not going to specify which one, but it's one of the largest banks in the world. Generally a very aggressive bank, from our other client cases. In this case, based on the structure that we set up to protect the doctor's assets, the bank simply walked away. They did not try to litigate. They did not make any arguments. They did not make any threats. They did not even try to negotiate. They simply walked away. Now, we obviously cannot guarantee that result to every single client. Sometimes it works out wonderfully like this. Other times you have to defend your structures. But if this doctor, pursued option A, meaning he never tried to protect his assets, the bank would have just simply gotten a judgment, gotten all of his assets. But he tried to do something to protect his assets. And in this case, it worked fabulously well. He was 100% successful. So I believe that in asset protection planning, it is very rare that doing nothing is the better option. In almost all cases, it is never too late to plan. Because even if it's a fraudulent transfer, the worst that can happen is they unwind the transfer. The client is right back where he started from. Okay, let's keep moving on. As I mentioned about an hour ago now, we can do, and we do, different planning for single people as opposed to married people. Why is that? From an asset protection standpoint, there are two types of states in this country. There are the common law states, which is the vast majority of states, and there are the so-called community property states. These are the 9 or so states on the West Coast, like California, Nevada, and so forth. And from an asset protection standpoint, it makes a huge difference depending on which state you live in. So, for example, let us say that our client lives in New York, and the client is, let's just stick with this real estate developer. The client is a successful real estate developer. Let's say it's Donald Trump himself, and he owns all kinds of very expensive assets. The client is married. His wife one day is driving down Park Avenue, and she runs over someone. And the question is, can that victim, who is now a plaintiff, once they get a judgment against the wife for her poor driving, can that victim go after the husband's assets? The answer is no, they cannot. The lawsuit was filed against the wife. The wife is the defendant. The wife is the debtor. And it's only her assets that the plaintiff can pursue. The assets that the husband owns, that's his separate property, has nothing to do with the wife and with her plaintiffs and her creditors. So in a common law state, one of the asset protection planning techniques, when we have one client who is exposed to a lot of risk, or a client who may be soon or is currently facing litigation, we may look at ways of getting the assets out of the hands of that client and into the spouse's hands. So the wife got involved in a car accident. What valuable assets does she own? And is there a way we can transfer them to the husband, okay, in a way that cannot be challenged by the plaintiff? Because once the husband owns these assets, they no longer belong to the wife, and the wife's creditors cannot reach those assets. In a community property state like California, the rule is completely different. In a community property state, if the spouses have community property assets, it means that each spouse owns 100% of the assets. Okay? Community property assets are owned 100% by each spouse. A lot of people, for whatever reason, believe that each spouse owns 50% of the community property assets. That is not true. 50% only applies on divorce and on death. During marriage, it's what's called a coextensive ownership interest. Each spouse, both the husband and the wife, own all of the community property assets. So if, again, the wife gets involved in a car accident and she is being sued, what assets can her plaintiff reach? The plaintiff can reach all of the assets that